Welcome to this free immigration help channel. Today is May 18th, 2023, and we're getting into the volume 94 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, before starting, I'm gonna mention I am not an immigration attorney. This is not a legal advice. All the information provided in this video on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question comment from Tatiana Markelova. Hi there, are there any ideas of when USCIS waives the COVID vaccine requirements for green card applicants? Tatiana, thank you very much for your question. That's a really good question. So I'm really hoping that they will really soon. We had some good developments in literally the past, less than a week. As of end of May 11th, so May 12th, starting from May 12th, they no longer require the proof of COVID vaccination for international travelers. So before it was only for green card holders, permanent residents, and U.S. citizens that you could enter United States without showing the proof of vaccination. That's it. This whole thing has been waived now. It's no longer in place. And after that, I think maybe it was actually before that, maybe like a day or two before that, it was World Health Organization that announced that we are finally no longer in pandemic. So just like that, it disappeared. So definitely, I wouldn't say great news because most of the people never really had any kind of whatever. This is a whole separate discussion. But with that being said, I think because they finally waived all that ridiculous, honestly to me this is ridiculous requirement, I think they might be waiving that requirement for people that are applying for the adjustment of status, people who are applying for permanent residence. As most of you know, as Tatiana, you know obviously that when you go through that medical examination, there's a whole bunch of vaccinations that are involved that you're supposed to have, and if you don't have them, then obviously during the medical examination, the civil surgeon, they perform these vaccinations and then they submit further for to USCIS or to the U.S. Embassy, depending on which adjudication process you're going through, right? Depending on how you're getting your permanent residence, how you're applying for it. So for that, we can just hope that they remove it soon, since it was already removed for international travelers, which would be great. For the rest of the vaccinations, I would recommend, and as I always recommend, is make sure before going to the civil surgeon for that medical examination, obtain as much of that vaccine history as possible. If you have it, because we get most of the vaccines, during our school days and, stuff like this. If we don't have the record, then the doctor would have to perform them. If you do have the record, then a lot of these vaccinations, they can be avoided. So I would recommend doing this. And as for, the COVID vaccine, we can only hope that it will be removed soon. I think it will be, and I hope it will be, because it was waived for the international travelers, so I think it's going to be removed for those who are applying for green card as well. Alrighty, let me put this, and we're going to move on to the next question coming from Therese Belido. Sorry if I'm mispronouncing the name. Very helpful video. Thanks for that. Thank you very much for watching. Please, I have a question. I'm applying for P3 visa and they ask for reference letters. So P3 is one of the categories within the employment-based visa. I would like to know if I can attach different letters from old dates. For example, I have reference letter from 2011 in English and I have references letter from last year in Portuguese. I'm Brazilian and I live in Rio de Janeiro. I was invited by a musician to produce a music festival in Houston. Oh, nice, that's awesome. I'm a performing artist, a performing art teacher, a screenwriter, and a producer. Should I also attach my curriculum proof too? Well, if you could help me with these necessary documents, I would be very grateful. Thanks in advance. Yes, so absolutely, Therese. Thank you very much for your question. You can definitely attach all of that information. In fact, I would recommend attaching all of this because it would be helpful. First of all, yes, these letters, of course, from 2011, it's 12 years old, right? but it also shows that you have been consistent in your career as a musician throughout all this time. Basically, you were active. So my recommendation would be, if you can obtain something recent, right? Say maybe 2 or maybe 3 recommendation letters from someone you can get within the past, 6 months, dated within the past 6 months, would be great. And then of course, yes, the additional stuff would never hurt. In fact, it would do only better, because it shows that it's not just within 6 months you started doing music, but you were acting in your line of work basically all this time. And yes, absolutely, I would definitely recommend attaching a CV, the curriculum vitae, whatever it's called, basically showing all the history of, showing the your career path, basically everything that you were involved in, all of the projects, maybe your musical work background, educational background, if you have such. That would definitely be helpful in determining that application and getting that visa. And also have that, I would recommend having that prepared, printed out in a separate folder when you go for an actual visa interview, so that just in case, if they have any questions, you can always open up and say, yeah, look, there you go. It's not just somebody's inviting me for, to do some kind of project, or, participate in, you said, your music festival, because they just found out about me. But no, I've been doing this pretty much all my life. So that definitely would be helpful. So thank you very much for your question. I'm going to pause this and we're going to move on to Noman Kundmiri. Sorry if I'm mispronouncing the name. Noman, thank you very much for being publicly subscribed. I really appreciate this, what this icon means. If the spouse of green card holder has a valid visit visa and wants to extend his stay in the US by filing I-539, would he need to file the extent of non-immigrant visa before the authorized days expires, or he can directly apply for I-485 soon after landing US? Thus, any of the above decisions would affect I-130 processing, and the stay in the US after filing I-593 and I-485 would be considered as legal. Noman, this is excellent question. Thank you very much for asking. So, I'm assuming that you do have already an I-130 in process. All right, if you don't, then I would definitely recommend filing it as soon as possible, all right? Because it takes time, even, especially considering that it's a permanent spouse of a permanent resident that is F2A category, and it does fall, unfortunately, under the family preference categories that are experiencing the backlog. So you will be dealing with, some time that is involved that you will have to be, waiting for. So as soon as you file the I-130, the better. I'm assuming that you already have the I-130 in process. So with that being said, you have the I-130 in process and you have a separate non-immigrant visa that, you arrived into the country and you are in the country on that duration of stay from the non-immigrant visa. So you got it definitely right. I-539, that is going to be applicable. You would have to keep filing that extension, if they approve it, or, hopefully they approve it. Hopefully there's no problems. Typically, they don't give you a lot of problems whenever it comes to the extension, of stay, especially because you have the I-130, if you do have the I-130 petition. You don't really need to worry about the I-485 unless you are already here and you are now filing the I-130. In that case, you do have an option to file I-130 and I-485 together. Honestly, it don't make no difference. Filing the I-130 right now and then I-485, if you're still here later, it's not going to make any difference than filing the just I-130 right now with, it doesn't really matter whether you file them together or separately. Really doesn't make any difference. Most likely what's going to happen, because you have been traveling back and forth, once the I-130 case is approved by USCIS and transferred to the NVC, most likely the NVC will give you an option to be processed either here in the United States in one of the field offices, and that's what this is the I-485 that we're referring to, the application for permanent residence, or get your case processed in the US Embassy in the country of the beneficiary. So if you're a beneficiary in this case, then you will be going through the interview in the country where you are coming from. Whichever way works for you better. What I would do personally is I would just do I-130, because it takes, especially in the F2A category, because it probably will take a year and a half possibly for whole processing, and then see where you're at. Are you still here in the United States? Maybe you filed your I-539 and your stay here was extended, and now you can stay here another 6 months, and now you are already approved by USCIS for your I-130. So now you have an option to go through that interview here in the field office. Or maybe you were not able to get the extension of stay, and you had to go back, and you're over there, and you have to go through the US Embassy in that country to get your immigrant visa. Regardless, really doesn't change anything. But one important thing to keep in mind is that yes, absolutely, you do have to maintain that legal status in the United States of America with being within that duration of stay. Because I actually got a comment one time, a person, I think she didn't realize that, just because she had I-130, her husband had, I think, I-130 filed for her, and she was here on, I think it was either student visa or B1, B2 visa, she actually let it expire, the visa. And she thought it was okay because she has a pending I-130. Pending I-130 does not give you, unfortunately, it's silly. I wish it did. It would be smart for, the whole Department of Homeland Security to do that exception for people, who are in the process, in the family reunification process. It would be smart. But it is not. It is not. The I-130, just having pending I-130 does not give you the ability to legally stay in the United States. So if your status from your B1, B2 expires, then you're in trouble. You're in trouble because you're now within that inadmissibility clause, and that's a whole other conversation that you have to be dealing with, and you definitely don't want to be dealing with this. So if you're planning to stay here, make sure you're filing these I-539 extensions. And as long as you have right now the I-130 in process, just keep waiting until it's approved by USCIS, transfer to the NVC, and then through the NVC you will be able to have an option. If you're still here, process here. If not, then in the country where you are coming from. So Noman, thank you for your question. If anyone, Noman, Therese, Tatiana, if anybody who's watching these videos and got answer from me and something is not clear and you have a follow-up question, don't hesitate to ask them. Just make sure don't respond to my comment within your comment with a question, because I don't see those notifications. Just submit a separate comment in any of the videos and I will be happy to come back to it and address it. All right, let's move on to the next one from Patricia Boner. Hello, sir. I'm filing for my daughter over 21. Her priority date is June 2016 and she is documentarily qualified in October 2022. Oh, congratulations. That's great. She is now waiting on medical and interview. I would like to know how long do I have to wait to get my daughter. All right, so your daughter is either in F1 first preference category, children of US citizens over 21, unmarried, or in F2B. Now, you didn't say if she's married or not married, but I'm thinking that she's unmarried, judging by the dates. But I'm gonna use this as an opportunity to demonstrate everyone how to do rough estimates using the visa bulletin. That's what we are dealing with whenever it comes to those family preference categories that are dealing with the backlog. And we have backlog on these immigrant visas because there is limited amount of them that is issued annually, and that's thanks to the Congress. Unfortunately, we have a limitation on how many immigrant visas people can get annually. So if there's more applications coming in than there's available visas, obviously there's backlog that accumulates, rolls over to the next year, then accumulates some more, and then rolls over to the next year. So that just grows and gets worse, unfortunately. Or there's another option that might be the case. It might be F2B, which is sons and daughters unmarried, over 21, of permanent residence. But it doesn't really matter because they're very, very similar dates. They're not too far from each other. So let's take a look at the first preference first, unmarried sons and daughters of US citizens. So let's see, we have graph A showing 2017. We know that she was already documentarily qualified, which is great. It's a huge milestone. So we're looking at the graph A, which is final action dates, which means that the final action on that case was already taken, meaning that it was documentarily qualified. Documentarily qualified is the final action. So let's take a look. Let's see. So the priority date is in June 2016. Okay, June 2016. Let's take a look. We have December 2014 immigrant visas that are being issued right now. So looks like December 2014, people who have filed their I-130 petitions back in December 2014 are just now in F1 category, are just now getting their immigrant visas. Meaning that just now they are, as of May 2023, they're getting their immigrant visa interviews finally scheduled, December 2014. So Patricia, your daughter is priority date in June 2016, which means that if she's in first priority category, F1, if you're a US citizen, that she has roughly, let's see, so this is pretty much 2015, roughly, because it's December 2014. Let's see, June, so about a year and a half, roughly about a year and a half more to wait for an immigrant visa interview. If your daughter is in F2B category, which is also possible because she was already documentarily qualified, then we are looking at, because they're processing now September 2015. So that means that she is about a year, wow, no, actually, no, less than a year. Sorry, yes, my mess is absolutely horrible. So June 2016, September 2015. So yes, definitely less than a year. Like 7-8 months. Please do a calculation for me. Absolutely horrible mess here. That's why I deal with legal stuff. Unfortunately, I have to deal with mess with this visa bulletin, but yes. So less than a year. Less than, if you're a permanent resident, Patricia, and your daughter is unmarried, then less than a year. If you're a US citizen and your daughter is unmarried, then roughly about a year and a half. I know it sounds a little bit strange. It's a little bit weird because you would expect that, children, whether they're, over 21 or unmarried, doesn't really matter, of US citizen would be processed faster, especially in first preference category. But as you can see, judging by this visa bulletin, why this happens, I actually did a video where I compare F1 with F2B and why that happens and which one is, because sometimes they do give you an option to switch if, for example, during the process of, while you're waiting for the I-130 to be approved, while you're waiting to become documentarily qualified, a petitioner who was a permanent resident, they might have gotten already they might have already became naturalized. In that case, NVC gives you an option to switch from F2B to F1. Sometimes it's better, sometimes it's for worse. Sometimes you want to do it, sometimes you don't. In this case, you probably don't want to do it, definitely don't want to do it because it's showing less. Again, this is not as accurate as we would expect it to be, unfortunately. So there's still some play in there between the dates. So I always say that all the estimates that I give are very rough estimates, but we will see. We will see. That's why every month the new visa bulletin comes out. I make a new video on each new visa bulletin and discuss and compare with the previous months, and we discuss how much certain categories moved. Okay, so Patricia, I hope I was able to answer your question. Let me know if you have any follow-up questions. I will be happy to address them. Let's move on to the next question from Trudy Bubs. Trudy, thank you very much for another comment. Really appreciate it. Hello, sir. It is so disappointing that the visa bulletin has not moved. Yeah, I know. How long do you think I have to wait for my interview? F1 category, priority date April 2015, documentarily qualified June 2021. All right, Trudy, so let's take a look F1, we were just talking about it. So if I remember correctly, you are in all chargeability areas. So chargeability areas, for everyone who's watching, is basically there's only 4 countries that have a separate chargeability area. That's China, Mexico, Philippines, and India. All the other countries of the world are in all chargeability areas. So unless you're from China, India, Mexico, or Philippines, you're looking at the all chargeability column. So let's take a look. F1, December 2014, and Trudy, you are in April 2015. So December 2014, April 2015. Okay, so you are January, February, March, April. So you are like 3-4 months. 3-4 months away from having that, the availability of the immigrant visa. Keep in mind that, of course, it also depends on the scheduling of U.S. embassies, because, in some countries, U.S. embassies are a little bit busier than in others, but you only have 3-4 months for the availability of the immigrant visa, at least according to the June 2023 visa bulletin. And really, at that point, it's just a matter of getting your interview, scheduled by the U.S. embassy. So you're really, really close, Trudy. All the tough stuff is done already. It's just really a matter of, medical examination and going for that interview and getting that immigrant visa and coming here. And as soon as you enter the country, United States, that immigrant visa automatically becomes a temporary permanent resident card. So you're almost there, just a little bit more. So let me put this, and we're gonna move on to the next question from Rebecca Suarez. My husband's priority date is April 2021. He has been documentarily qualified May 11th, 2021. He is IR1. Okay, cool. When will he get an interview from consulate in Juarez, Mexico? Rebecca, I imagine Juarez, Mexico must be a pretty busy embassy. IR1 on the plus side is immediate relative category, so the immigrant visa is already available for your husband. It's just a matter of scheduling. Now, whenever it comes to scheduling of the interviews, typically, it takes about 6 months, maybe sometimes, 6 months to 9 months, usually, all right, most of the times. I have seen some situations where it can take up to as long as 1.5 years, and I've seen some of them take as fast as 3 months, all right? The longest one I've seen in immediate relative is 1.5 years. What you can do, so it's been 1 year already for you, so you've been waiting just over 1 year now for that interview. So might potentially wait another 6 months, possibly. But Rebecca, what I would really recommend you do is I would recommend reaching out to the U.S. Embassy in Juarez and just be nice over the phone, be polite, professional, and say, hey, my husband is, immediate relative category. He was already documentarily qualified 1 year ago. I just wanted to see how your scheduling looks for immigrant visas in family preference categories. When do you think my husband is going to be scheduled? Don't be upset if they don't give you any information, because it's at their discretion to provide that information. And a lot of times they say, sorry, we can't provide that information. But sometimes I've seen cases where they open up the computer and say, oh yeah, we have, our next available appointments are like 3-4 months ahead. They don't schedule 3-4 months ahead. They have to schedule right now within 30 days because of the medical examination. But there's actually some changes that they're trying to implement at the Department of Homeland Security, where the medical examination can be done a lot earlier than like within 30 days before the interview. So if that happens, obviously it would be good. But Rebecca, it's literally, you're almost there. Been waiting already for 1 year for an interview, so I think it should be anytime now. But give it a shot, because like I said, sometimes you get a nice person on the phone and they're okay with giving you that information. Just checking the date really is not a lot work for them to do that. Alrighty, so let me put this and we're gonna move on. Rebecca, another one, same question. I'm gonna do this. We're gonna move on to the next one from Sir Good. Sir Good, thank you for another comment. Thank you for being publicly subscribed, as always. Hello, brother. As you told me in the past, I have asked the embassy by email, and I'm waiting for their response. My question today is that according to the June 2023 visa bulletin, my immigrant visa is now available, right? All right, let's take a look. I don't remember. So your priority date is December 2016, F2B. Okay, so December 2016, F2B. Let's take a look. F2B, December 2016. Okay, so actually, sir, good. So actually, F2B 2016 December is showing September 2015 that the immigrant visas are becoming available, which is your, let's see, December 2016. So you're almost in 2017. So you are, man, my math is absolutely horrible. You are less than a year, probably what, like 10 months. So you might be waiting roughly another 10 months before your interview is scheduled, because according to the visa bulletin, it might not be still available. Okay, but because you were already documentarily qualified, it means that it was already, because you have to keep in mind that if you are documentarily qualified, they don't allow you to become documentarily qualified unless you are already very close to the availability of the immigrant visa. So looking at this is a very rough estimate, but it's not one of those estimates where it's like, okay, so this is a guarantee, this is the time that I'm going to wait, and then that's it. Because some people, you see in a lot of situations, their immigrant visa is already available. Like with, husband of Rebecca, his immigrant visa is definitely available because he's in the immediate relative category, but he's still waiting for a whole year in order to get his interview. And sometimes you get it earlier than that because the U.S. Embassy was not as busy as in some other countries. So I would recommend waiting for a response from the U.S. Embassy. Once you get the response, please come back. Let me know what they responded, because I would honestly be really interested in hearing, because it's hit and miss. Sometimes they give information, sometimes they don't, but judging by the visa bulletin, you still have roughly 10 months before the availability of the immigrant visa. All right, let's move on to probably our last question comment for today from Gitanjali Prasad. Sorry if I'm mispronouncing the name. Hi, I am in F4, first priority category. My priority date is 4 June 2007. I am from Guyana, I think, or Guyana. I am documentarily qualified in August 2020. When do you think I will get my interview? All right, let's take a look. So F4, that is first preference category. That is brothers and sisters of U.S. citizens. And unfortunately, it's the category that takes the longest. So Guyana is all chargeability area. So let's take a look. Already documentarily qualified in August 2020. Priority date is June 2007. So we're looking at graph A, June 2007, and right now they're processing April 2007. Wow. So you are, let's see, April, May, June. Wow. So you are like 1-2 months. Sorry, I'm an immigrant myself. 1-2 months away from the availability of the immigrant visa. Again, it's not really an indication of when your interview is going to be scheduled, because they're waiting for the availability of the immigrant visa in most of the cases before scheduling the interview. Sometimes it's an exception to the rule depending on their availability, but a lot of times they do. But roughly 2 months and your immigrant visa is going to be available. Definitely, I would recommend staying on top of the issues of the visa bulletin. Hopefully, May, like Trudy mentioned earlier, June, what just came out for June 2023, there was absolutely no movement that was showing, which is kind of sad to see that copy-paste visa bulletin. But really, hopefully, in the next couple of months, we will see some movement again, and we will get it. But I would definitely recommend Gitanjali. I would definitely recommend, once you get to let's see, April 2007. Once you see this right here move to June 2007 in the visa bulletin, I would definitely recommend reaching out to the U.S. Embassy And let's actually, I'm going to use this as an opportunity to demonstrate this website, embassy.gov. So it is usembassy.gov, and let's see if I can find I know it's not Guyana. There you go, Guyana. I don't know. Ghana. There's Ghana and there's maybe Guyana. Maybe I said it right, correct. I don't know. Okay, so this is it right here. We're gonna click on this. There's only one, and there's a phone number right here. So once you see it on the visa bulletin, get to June 2007, give them a call and give it a shot. They might be able to give you the information and tell you when approximately to wait for that immigrant visa. But you know, you've been waiting since 2007. That is a very long time. That is 16 years. 16 years. So you've done all of your waiting already. So it's really around the corner, somewhere around the corner. Just a little bit more patience, and it will be right up. And all you guys know that I myself have an immigrant petition for a family member, and the I-130 petition, waiting for that, and I will be waiting for another 13 years. So when I say I wish you guys patience, I mean it. I don't just say like, oh yeah, be patient and be patient. No. It's personal. I definitely know exactly how it feels. That's one of the reasons why I started this channel. So I really hope my answers have been helpful today. If you have any follow-up questions, don't hesitate to ask them in the comments below. Thank you very much everyone for watching. I appreciate your time. God bless, and I'll see you in the next video.